Today, it's my honor to introduce to you Dr. Stephen Ross, coming to us from the University of Washington at Tacoma. Steve has degrees from Roger Williams University in Bristol, Rhode Island, then earned his master at Ball State University in Muncie, and his PhD in legal psychology from the University of Texas at El Paso. He has since then held faculty appointments at Florida International University, and is now, as I said, an associate professor of psychology at the University of Washington at Tacoma. And he'll talk to, most of his research has always centered around eyewitness memory and identification. And today he'll talk to us about some reforms that they've been working on in the state of Washington. So please join me in giving Steve a big
Thanks, Andre. Good afternoon. How you guys doing?
Good.
You okay? Thank you for coming out. 3:30 on a Friday afternoon. I'm sure you probably had places you'd rather be, so I didn't schedule the time. You can blame Andre for that one, okay? But I do thank you for coming out, and also thank you for the invitation to come out here to balmy North Dakota. I know it's warm for you guys. It's a little bit cold compared to Seattle right now. So how many of you are familiar at all with like eyewitness psychology and theories of decision making and all that? So there's a good amount of you. Good, okay. For those that aren't overly familiar with it, I could have spent my time today talking about our research that really looks at like the theoretical aspects of eyewitness memory and decision making and all that, but I don't want to bore most of you in the room with that. So I decided rather what I wanted to talk to you about today is some work that we're doing in Washington State that looks at how we can take our knowledge of eyewitness psychology and use it to inform public policy, specific in the area of law enforcement investigative practices. And what I'm hoping you take from today's discussion is not really necessarily the specific content that we're developing and the specific reforms that we're trying to put into place, but rather looking at different approaches that have been attempted throughout the country to enact reform based upon science-based practices, and see what are some of the limitations of those approaches and why what we're doing in Washington is different and what we feel is going to be a more effective way to actually get change in the day-to-day practices. And so, although you might not have any specific interest in eyewitness psychology, I'm hoping that what you might take from today, you might see that there might be an application in your area of expertise when you're saying, okay, down the line, if there's an opportunity to employ evidence-based practices in some applied setting, bringing it to a community that's traditionally non-scientific, what are ways that we can go about doing that to affect actual change in that non-scientific community? And so that's why I wanted to focus on that today with you, rather than talk about basic eyewitness stuff that most of you would probably start rolling your eyes about halfway through the talk, okay? That said, the reason why eyewitness reform has become an issue is because of the limitations of eyewitness testimony. And really what we've seen over the last 25 years, 30 years or so, is more and more cases here in which we're now finding after the fact that innocent people are being convicted of crimes, right? And that because of especially the advent of DNA testing back in the 80s and first being admitted in court in 1989, we're starting to see more and more evidence here of innocent people having been convicted of crimes, and then they're able to prove their innocence after they've been convicted, which is, anybody that knows the legal system knows that that's an extremely difficult, if not nearly impossible, process to do. And so what we know is that since 1989, eyewitness misidentification has contributed to 625 instances of proven wrongful conviction in the United States. That's not 625 instances of wrongful conviction, it's just proven, what we've been able to prove definitively after the fact, right? We know, actually, that there's been over 2,100 instances of proven wrongful conviction since 1989. And what we can look at here, as we started to get more and more evidence of these cases of wrongful conviction, we start seeing that eyewitnesses are playing a significant role in these miscarriages of justice. We look at DNA cases alone, where now we have truly definitive evidence that somebody's innocent, right? Say it's a single perpetrator crime, single perpetrator sexual assault, right? Somebody gets convicted, post-conviction DNA testing conclusively demonstrates that they could not have been the contributor of that biological specimen. There's no ifs, ands, or buts as to whether they could be the perpetrator or not. It's clear that they're not. In those types of cases, we can see that 70% of them involved a witness, victim, mistakenly saying, that's the person that assaulted me. That's a huge number, right? And so we started seeing in the 80s and 90s that these errors were coming about, and the question started to emerge of, all right, what can we do about this? Is there anything that can be done to try to reduce these errors from happening in the future? What can we do to get better evidence from witnesses, okay? Now, one thing that people have said is, okay, we should just stop relying on witnesses. They're completely unreliable. We shouldn't rely on them anymore. But that's not feasible. We can't do that. There's people that argue for that, but we can't do that. And that's because they play an integral role in our criminal justice system. Now, there's no really good records of how many ID procedures are conducted on an annual basis, but we can get estimates, all right? We've just done some studies in Washington, some of which I'll be talking about with you today, and one of which we surveyed 314 commissioned officers in Washington. We just asked them, how many ID procedures have you conducted this past month? And different types of ID procedures they've conducted. And we also asked them to estimate how many have you done in the past 12 months, okay? So of these 314 officers from across the state, they reported that in the past month they conducted 423 ID procedures. Right? That's over one a month per officer. Right? And in the past year, they estimated they did over 3,500 in the past year. Well, that's only 314 officers. If we extrapolate that to the 11,000 plus officers in Washington State, boy, they're being used a lot. Right? We also have national survey data. So PERF did a survey published a survey back in 2013. Here they didn't ask individual officers. They rather just sent the survey to agencies and asked somebody from the agency to report how many that agency had conducted in the past year. But what's important about this is that they found that these agencies reported conducting over 23,000 in the past year. And again, if we extrapolate out to the over 15,000 agencies in the United States, that estimates out to 1.5 million ID procedures a year. That's a lot. So we can't just sit there and say, let's not trust witnesses and not use them anymore. They're playing an integral role in the system. And so now we have to figure out what can we do in the system to try to get better evidence from these witnesses. We're never going to get 100% accuracy, but can we get it so we're relying on better evidence from the witnesses? And so based upon this, what I want to talk to you about today are four things. There's four purposes of today's talk. The first thing I want to go over with you is to review what have been the efforts that we've engaged in to reform practices related to how we go about collecting the eyewitness evidence. Then related to that, after talking about what those efforts are, and in the process of talking about what those efforts are, I'm going to outline four general approaches that have been taken to doing this. And again, as I mentioned early on, these are the same four general approaches that can be taken to address public policy in any legal setting, not just an issue of eyewitness identification, okay? Then we're going to talk about the limitations and effectiveness of these approaches. And then lastly, I want to talk about a novel approach that we've been working on in Washington State that, as you can probably guess, my argument's going to be that there's been a lot of limitations and ineffectiveness of the other approaches that have been used, and propose to you today a different approach that we believe will increase the effectiveness of this policy reform and provide you some evidence as to why we believe that. Okay? So first, let's start at the beginning. Where did this reform come from? Where did it begin? And really, the first efforts to reform procedures in the United States came about in 1998. We started to get more and more evidence of these eyewitness errors being the chief contributing factor to these DNA exoneration cases. And so Janet Reno was the Attorney General at the time. She said, we need to do something. As the law enforcement agent of this country, I need to put together a group and try to figure out how can we address this. And so She put together this group of 34 members representing all aspects of those that have a vested interest in eyewitness issues: prosecutors, law enforcement agents, defense attorneys, and scientists. And those that know the eyewitness field might recognize some of the names like Gary Wells, Roy Malpass, Ron Fisher, Rod Lindsay. They were the preeminent scientists at that time in this area. And they were all on this committee, worked together, and they put out their best practices. It's been referred to since then as the guide. It is the guide for how to do eyewitness investigations. And they put this out in 1998, and it was the first effort. Now, it was a guide, though. They couldn't mandate it because our Attorney General doesn't have the authority to mandate to states what to do, right? That's our federalist system, that the federal government can't mandate the states on what exactly they have to do. And so this was out there as a recommendation. But after this came out, since that time, 19 states have enacted some sort of reform in regards to how they collect eyewitness evidence. Notice North Dakota is not on this. South Dakota isn't on this, right? Minnesota is not on this. There's a big void in the upper Midwest that you're missing here. So if anybody's looking for where you can make an impact, here you go, okay? So we see 19 states have enacted some reforms since 1998. The first that actually did it was New Jersey in 2001. And then since then, 18 states have followed suit. But there's also multiple independent agencies that have voluntarily gone along and done reform too. Many more than what's listed here. These are just ones that I know of. I went and looked. I couldn't find any in North Dakota that have done it. If you know of some, I would love to hear about it. But I don't know of any in North Dakota that have actively gone and changed how they go about conducting their practices. These states and these independent agencies have all taken one of these four approaches, and some actually have tried two because the first one they tried failed, and so they tried a second one. But I want to talk about what each of these entails. There's one approach is to try to enact reform through judicial decisions. So try to use the judicial branch of government to address law enforcement practices. That's one approach that's been taken. I'll talk about that in a minute. Another is through administrative efforts. That is that voluntary compliance that the administration of each agency decides that we're going to make a change. The third approach is through legislative mandates. Like what it sounds like, that's where the state legislature just gets there and says, no, you're going to do this, we're going to make this a law, and they pass a statute. And the last is something that Keith Finley has recently described as democratic experimentalism, and I'll talk about what that is here in a little bit. It's a hybrid of some of these approaches. So first, let's look at judicial approaches. The judicial approaches have taken one of three routes to try to get through. And basically, all of these are the same thing. These are approaches that aren't telling law enforcement what to do, but they are approaches that the court is taking of saying, this is how we're going to go about evaluating the evidence when it comes to us. How we're going to come about making decisions about eyewitness evidence and this type of evidence. And the idea behind it is that if the court changes how they evaluate their evidence, it will ultimately lead to change in how law enforcement collects the evidence, because law enforcement is going to collect the evidence in a manner that's actually going to be consistent with how the court's going to evaluate it. Does that make sense? So it's not a direct effect, it's an indirect effect on law enforcement practice. Does that make sense? Okay. So the first of these is to try to influence how the court evaluates the reliability of the evidence. Not the jury, but how the court evaluates the reliability of the evidence. And basically this involves two processes, or two approaches that they've taken, okay? One is they've gone out and they've rejected what is an antiquated approach called the Biggers-Brathwaite approach. These was, Biggers and Brathwaite were a pair of decisions back in the 70s by the US Supreme Court that basically set out to the court, this is what you look for to determine if it's reliable evidence from a witness. The problem is that the court decided on what to look for. They didn't really go to the scientists that said this is what matters when you're deciding on what's reliable. And so they set it out in the 70s. It's still used in most jurisdictions as the criteria, but we know from decades of research that many of the things that they say to rely on are not good indicators of witness accuracy. And so the court's relying on antiquated concepts, okay? So they've rejected that and instead say, instead of relying on these things that don't work, we're now going to rely on science-based practices. We're going to rely on focusing on the things that science says are related to the validity of the witness's statements, the validity of the witness decisions, and that's what we're going to rely on there. And many of these are things that law enforcement has control over, right? Like what instructions you give to a witness, right? If you give the witness any like leading information when you're questioning them, right? Because that can contaminate their memory, things like that. And so in essence, the idea behind it is that if we say we're going to look at how you're doing your investigations, and we're going to decide whether we're going to admit testimony based upon that, then ultimately it should change law enforcement practice to be consistent with how they're going to look at it. Does that make sense? So that's one approach. The other is to focus on how jurors are evaluating the evidence. And this is typically done through jury instructions, mandating that certain instructions should be given to the jury to explain things like cross-race identification. You guys familiar with the cross-race effect? You guys have probably heard the people say they all look alike to me. You know, the reality is they do, okay, right? We are much better at recognizing individuals of our own race and ethnic groups than we are of others, and it's not about racial bias, right? It's not it's not about a social bias aspect. It's about a cognitive processing component of it there, okay? And so giving those instructions to juries, they believe is now going to help the jury evaluate the evidence in a case, okay? Anybody do research on jury instructions? Are they effective?
No.
No, okay. So, I mean, the court says this is what we'll do, but typically we find jury instructions aren't effective at making jurors better able to evaluate the evidence for a variety of reasons. Don't ask me, ask her, right? And the last approach was just to appoint like a task force to say, hey, we're going to mandate, or we're going to put out a court order saying that we need to develop people to provide recommendations, okay? Now, the limitations of these approaches, you guys might be sensitive to, I mean, anybody see what limitations might be of some of these approaches, or of this approach?
Any of them?
Any of them, just the judicial approaches broadly.
Not based on science?
Well, the hope is that it is based on science, right? I mean, is this a laser pointer? Oh, it's green, okay. Right, the idea is that we're changing to focus on science-based approaches. The old approach, that was definitely a limitation, but they're trying to change the focus on science. Yeah?
Judge compliance?
Judge compliance, right? So say that, is the judge actually going to abide by this in any specific case? Are they going to deem it inadmissible if it doesn't meet that practice or not, right? Yeah.
Can they, in fact, apply this relevant standard?
Can they actually do it, right? I mean, I expect Richard would throw that out there knowing that judicial knowledge is limited, right? And so are they even capable of doing it, right? Let alone will they do it? Are they even capable of doing it given their education, right? Yeah.
It's essentially working backwards because you start with the court and then you're going to go down to the lower courts. So it's the prosecutors telling the agents and the cops and then to the witnesses.
The trickle-down effect, doesn't it?
Right? It's a trickle-down effect, right? You're starting at the end and trying to work yourself back to the beginning, right? Is that what you get at there? Right? Exactly. Anything else?
Yeah, people don't like to be told what to do.
There's a big one. That one's going to come up a couple times here. Right? Okay. Yeah, I mean, you're identifying some key limitations, some of which I don't even have on here. I didn't even think about I have the will thing, but I didn't even think about the ability aspect of it necessarily like that, right?
And how much research is out there to base it on?
Well, I guess that would be a broad limitation of maybe all of these approaches as well, right? Yeah, is there a good enough base for the research, right? Or is the research base good enough for making these decisions, right? Some approaches that we've seen and that have been published about are things of that reactive nature. It addresses the problem after the fact, right? This is how to prevent the mistaken identification from leading to a conviction. It's not about how to prevent the mistaken identification from occurring to begin with, right? So it's reactive in nature, right? Plus, in order to even get these passed, there needs to be both a will and an opportunity on the part of the court, right? The court has to want to make some sort of decision about eyewitness issues, and they also have to have a case in front of them that they can. They can't just decide to make say, well, this is how we're going to go about evaluating the evidence now, unless there's a case that's related to this that they can do. It's how our court system works. They have to wait for the opportunity to come. To give you an idea of this, and I'm already going over time, so I'm going to have to blow through some things. In Washington, there was for years, there was a rumblings that the state Supreme Court wanted to address eyewitness issues in a case. right, that they wanted to address and come up with some way to do judicial reform in the state of Washington. But people heard that the Supreme Court justices were willing to do this, but there was never a good case that was coming through that they could actually make the decision on. And so what defense attorneys were doing in the states, like the Washington Defender Association and Wachtel, the criminal defense lawyers, they were sitting there and looking for cases that had lost at trial that would be ripe for appeal that they could try to go up. And in my opinion, they found the case that they could put up, but it was a horrible case to put up because it wasn't one in which the eyewitness evidence was really that controversial. It was pretty strong eyewitness evidence in this case. But they found one, they threw it up there, and because of the constraints of the court, they had to only evaluate the facts of the case. They ended up not making reform because the case they put up was so weak in nature. Does that make sense what I'm saying? Right? And so they wanted to do something about it, but the opportunity wasn't presented to them that would allow them to do so. Okay? Let me move on to another one. This one is real quick. This one is administrative efforts, voluntary compliance. Basically, agencies sitting there and saying, oh, wow, there's problems here with how we're doing this. I know that there's better ways that we can do this. I've read about this. Let's go and voluntarily go do this. Okay? That's the voluntary compliance approach. And it's been done in a bunch of different jurisdictions. I don't know all of them, but it's been done in a bunch of them. And typically, these approaches are the policies they enact are consistent with what's been put out by law enforcement organizations, National Institute of Justice, CALEA, IACP, that have sat there and said, oh, well, there's a problem. We're going to recommend that you guys do it this way. Now, there's limitations to this, though, too. One of these is the fact that it's a very, well, I guess the first one I have here is that it's self-initiated. The agency has to have the will themselves to do it. And if the administrators don't care, it's not going to happen. Right? It's also really piecemeal. It's a slow approach. There's over 15,000 individual law enforcement agencies in the United States. If we include sheriffs into that, it's over 17,000. Right? To have to go from one to the next, to the next, to the next, to the next, to the next to get reform is a very slow process. Okay? And also, it's insular. Like I said, they're relying, the reforms they do are typically because they've read about it in other law enforcement sources, right? So it's an insular process. They don't reach out to the scientific community to ask for information as to what they should be doing. They just read about it in some other law enforcement journal and say, we're going to do that. And it ultimately results in them changing a process, focusing on what to do, but not exactly why they're doing it. And oftentimes then they'll tweak an aspect of that process or of that practice, and all of a sudden now it's not effective anymore. And I'll show you an example of that here in a little bit. And so there's limitations to this approach as well. The third approach, and this is by far the most common approach, is the legislative mandate. This is where the state legislature will then go and pass a statute that says you're going to do this now. All right? And these typically have one of three sets of requirements. Some are very heavy-handed, very authoritative, and they will specify specific policies and procedures that law enforcement has to do. Okay? This will be, you will give these instructions. The law will stipulate these instructions must be read to the witness before they participate in the ID procedure. This is exactly how you must administer the ID procedure, and it's very prescribed and specific. All right? Others say, you have to have a model policy that addresses this, or you have to have a policy, and you can either adopt our policy, we'll write one up, so we'll do the work for you, you can adopt it, or you can develop your own written policy that's consistent with what we have. Does that make sense? So they allow for more flexibility, but it must be very similar to what we've developed. Okay? And lastly, they just say, you have to have a model policy that addresses these issues, but we're not going to give you much guidance in what that policy has to look like. Right? You have to have a model policy, and in that policy, make sure you talk about what instructions you're going to provide to the witness, but we're not going to give you any guidance on what those instructions should be. Does that make sense? Okay, but they mandate it. All right? The problems with this, again, some of these are the will issue. It requires that the politicians have an interest in doing so. Okay? Also, especially the first approach that they use in North Carolina and Ohio and in New Jersey, is that it's a one-size-fits-all approach. So agencies that have a lot of officers have to do it the exact same way as agencies that maybe only have 4 or 5. Right? And sometimes for those agencies that only have 4 or 5 officers, it's difficult for them to do it the exact same way. They don't have the same resources for it, right? In Washington, we have Seattle Police Department that has about 1,300 plus employees. And we have some other departments, small departments on the east side of the state that have 4. And we're expecting them all to do it we would be expecting them to all do it the same exact way. And that's not really, what's what I'm looking for? It's not likely, right? It's something that, it's not fair to expect the same resources from the smaller agencies. Another one, which is perhaps one of the biggest problems with it, is that if it's a statute, especially if it specifies this is how you have to do it, what happens if 3 years from now we discover a more effective way to do it?
New legislation is required.
Yeah, the only way to do the new way is what?
New legislation.
Passing a new law. That's it. And do you think that's going to be another easy process to do? Do you think they're going to want to revisit it every time? They got plenty on their plate, right? They're not going to want to revisit it. And so these now become frozen in time, and there's no opportunity for advancement. Another problem, the last 2 problems, A, they're broadly written. I mean, legislation is typically requires parties with different interests to come together in some way and compromise for the legislation to actually get passed, right? And that compromise usually means now that you lose some of the punch of what you were trying to do. They become broadly written, they don't become specified enough, and ultimately now you're not getting the practice that was intended. And then lastly, as Richard pointed out, a big one with this is that, do you like to be told by people that don't do what you do, what you should do? You don't like it. You think cops like it more or less?
Less.
Less. There's plenty of, there's data out there showing that cops are a very insular organization. And as much as you don't like people sitting there and telling you, like many of you are grad students, right? And you tell your parents, I'm a psychologist, and then all of a sudden they think they know exactly what you do as a psychologist, right? Okay. And they clearly don't, and you don't like hearing it from them, okay? Cops are even worse on that. They don't want to hear what you have to do because you've never done their job. You don't know what it's like to do their job. You have no clue what it's like in the real world when you're dealing with criminals. And so it's very heavy-handed, and they just don't want to listen to the legislators, right? And so because of this, there was a 4th approach that kind of developed organically through states. It wasn't like people sat there and said, oh, we're going to try something new. It was kind of like just developed naturally. It's this less authoritative legislative mandate approach. And what they do here is basically they mandate you have to have a written policy, but they don't say this is exactly what you should do. All they say is that you need to develop a policy, and you need that policy to be compliant with science-based best practices. But the benefit of it here is that you develop it yourself. You take control over what is the practice that's going to work for you and for your organization, right? So that small 4-officer organization that doesn't have the same resources as the large one, you can develop, as long as it's consistent with the science-based practices, you figure it out and you do something that's consistent with that. And now you have the control over what you're going to do. Does that make sense? Right? So those are the approaches that have been done. The question that we have then, went too far ahead, is now that we've used these approaches, and 19 states have followed one or 2 of them. Georgia tried one, it failed miserably, they tried another one. The question is, how effective are they? Let me ask you this. In order for it to be effective, what are the outcomes that we would want to see to say that this reform effort has been effective? Yeah.
Reduction in wrongful convictions?
Perhaps reduction in wrongful convictions. Okay. Are there any other outcomes that would that we would want to collect to try to see? Yeah.
You could also see how many cases with eyewitness tests weren't charged. The prosecutor decided not to go ahead.
Okay, so looking to see how many weren't charged to get an idea of, are they increasing rejection rates of making decisions, rejecting more often eyewitnesses? Okay. Anything else?
I guess you could do like self-report measures.
Of what?
That's what I'm trying to think of. That part of it.
Self-report of something.
I guess of them, like, have they implemented and have they not implemented? Do they believe it's effective for their different districts, et cetera, those sorts of things?
Right? The purpose of this reform, especially the approaches that have been taken, is the end goal is if they mandate, what are they mandating? That you have to do what?
Science-based.
Yeah, you have to have a written policy, right? So one of the first things that we could look at there is to say, do they actually have a written policy,
Right.
right?
And is the written policy actually based on science?
Then is the written policy actually based on science, right? And ultimately the goal of reform is that we want to change what?
Behavior.
Behavior. So is it actually resulting in the change in practices that we want to see, right? So we can look for some of that evidence and see, do these efforts that have been taking place since the early 2000s actually changing any one of these outcome variables of interest? Well, the first one we can look at is, do they have a written policy? All right? Here's a table here that shows percentage of agencies within a specific state that have a written policy. Now, this first one over here on the left, this one I just want to show you here. That's that same survey that I talked about early on about how frequently they use ID procedures. This one shows that in 2013, only about 36% of agencies in the United States had a written policy on how to conduct eyewitness procedures. That's pretty low, right? But that's averaging across agencies that have done reform and agencies that haven't done reform, right? So 19 states have done reform. That includes the other 31 states and the District of Columbia that haven't done reform, right? And so we would expect that maybe that's being drawn down, right? So we can look here, this next batch of points on the bar graph are states in which either did not have reform or have not reformed, or the data was collected before they tried to reform, right? We can see really low numbers, right? States that have not reformed are less likely to have written policies. But let's look over here at Wisconsin, Virginia, Massachusetts, 3 states with written policies. What does this data suggest?
They're all fairly compliant.
That they're developing written policies, right? And so you look at this data, and especially if you present this to legislators, what are the legislators going to do?
Looks good.
Looks good to me. Pat themselves on the back. We did it. We solved it, right? We're good. They comply. They have model policies. 92% in Wisconsin. Great. Virginia, not that great. We can do better, but maybe it's just about enforcing the policy. But we're looking pretty good, right? They have written policies. But the important thing here isn't whether they have a written policy. It's whether the written policy actually is a good policy, right? When we start looking at that data, we start to get more depressed. Okay, or at least I get more depressed. I'm already depressed a lot, but you know, it gets worse, okay? Keith Finley looked at Wisconsin. Now remember, Wisconsin, the best, 92% of the agencies have a written policy. Found that only 26% of them adopted the model policy that was provided. But that's okay. They told them, you could adopt it. Here's a model policy if you want to do it, or you can create your own. So they don't have to do the model policy. But as we start looking at the other policies they constructed, oh, they are missing key components of what the practice should be, right? This one is the one that hurts me the most. 60% don't tell people that if you conduct a lineup, only put one suspect in the lineup. That seems intuitive, right? But I know, but trust me, I've seen cases in which its typical lineup has 6 people, and every single person in the lineup was a suspect, right? So if the witness just closes their eyes and points at one, you got him, right? Okay, right? It's bad practice, but they didn't say anything about it in there, right? So now we have a situation in which they're not doing their policy. Sure, they have the written policy, but it doesn't include what we know to be the practices that was the whole point of doing this to begin with. And if we look at Virginia, it's even worse in Virginia. Virginia, 8 years after it was mandated by law that they have a written policy, 20% still didn't. And if we look at what they did, it's even worse of how many are missing important components of the practices. I'm not going to go through what each of these are, but really important aspects of how to conduct good identification procedures are completely not included in their policies at all. So now, oh, well, we had 80% that had a policy, but most of those policies aren't good. But let's focus on the ones that are good. At least that means that they're going to, those jurisdictions, those agencies, they're conducting good ID procedures, right? Because they have the policy, and we all know that if you have the policy, that means it's exactly what the law enforcement is doing, right? We actually don't have good data on that. There's absolutely no research looking to see if law enforcement officers are actually engaging in the practices that their policy outlines. So we can't look at it directly, but we can look at it indirectly. In looking at it indirectly, we're not very happy. We're getting more and more depressed, okay? Right? We're all going to need to take a Prozac after this, okay? Right? What we find here in our data, which was kind of surprising, is many officers are completely unaware if their department has a policy or not. Not just like the department has a policy and they don't know it, but they're like, oh yeah, we have a policy, but the department doesn't have a policy. They're just completely, they have no idea whether they actually have a policy or not. And as Richard's demonstrated before in his survey of law enforcement, right? Few are aware of the recommended best practices, right? The interesting thing about the NIJ guide, that was sent to every agency in the United States. They have a copy of this guide. Only 25% of the officers in those agencies actually acknowledge that they know anything about it. Right? So they don't know what the best practices are. More from the reform agencies, but still this means that 45% of the officers from agencies that had enacted reform have no idea what best practices are. Right? That's not boding very well. And in our data, we found that 38% of, like this one, okay, the NIJ guide was published in 1999. Survey was conducted a decade later. Maybe they just don't remember what it is. They saw it. Ours, the WASPIC model policy was passed about a year before we surveyed them. And only 38% said, oh yeah, I'm familiar with it. Right? It's just not boding well that they even know what they're doing. And then lastly, we also know that many officers do not engage in practices that comply, right? Richard's demonstrated this too, that the officers just aren't doing it. They report, what they're reporting is not compliant with what these best practices are. So in essence, my argument here is what? How are these reform efforts? What about these reform efforts that have been done? They're not affecting behavior, and that's ultimately what we want them to do. They just haven't been effective. We've spent now nearly 20 years trying to reform practices nationwide, and we don't have any evidence that it's really resulted in meaningful change to the day-to-day practices of a criminal investigation. And so the question is, why? Why is it failing? And so my argument is that there's multiple reasons why these four approaches have failed. The first of these is something that we really can't do a lot about, but that's the lack of accountability. We can't hold law enforcement agencies accountable for not meeting these. You can mandate they have a model policy. Like I said, 8 years after Virginia passed the law mandating a model policy, 20% of the agencies still didn't have one. But there's no teeth. There's nothing that can be done. You can just say, well, you're not compliant. But there was nothing given that you could make them accountable for, right? So there was very limited consequences. I don't want to spend too much time on that because that's a different issue to deal with, and I don't have the time. Andre told me I talked too much to begin with. I can talk about that with you. One state, Oregon, actually enacted the most meaningful reform of holding officers, holding agencies responsible and accountable. Another important thing is, as we've demonstrated, is the limited follow-up on if these are effective or not. Many agencies or many jurisdictions, like 19 states, have passed some form of reform. Only 3 of which have actually done any studies afterwards to say, is it resulting in change in are these people compliant with what we've mandated? Does that make sense? Most of them haven't even said, okay, we passed the law, we're good. Let's move on to something else. And they're not following up to see if it's effective. And none of them have actually assessed whether the change in policy has resulted in change in practice. And so we don't know whether it's working or not. Nobody's followed up on it. A really important one is that they're not getting training on this. Right? We find that 32 to 62% of agencies report that they provide absolutely no training on how to conduct identification procedures. 0. Zip. Nada. No training at all. They just rely on what these officers got in their basic law enforcement academy. I had one case that I worked on in Washington in which this patrol officer was sent out to do a photo array ID procedure. And I'm looking at his report, and it's just a mess. And so I'm talking to him. I was there in court to testify, and I'm talking to him before I'm going to testify in the pretrial hearing. And I come to find out that he had been on the job for 22 years. This was the first ID procedure he was ever asked to do. And they just said, can you go do it? Didn't give him any training. He didn't have any training over that 22 years of being on the job. Just what he had in academy when he first became an officer. There's no training. How do we expect them to actually know what they're doing? Right? And Richard demonstrated this too, is that even when we implement new policies, it doesn't demonstrate that they actually develop increased knowledge of the issues, because we're not training them. We're just saying, do X, but we're not giving them training and knowledge of how to do it effectively. And lastly, this is the big one. And if there's one thing that I want to encourage you to take home today, is this. All too often when we work with non-scientific communities, when we are scientists and we're trying to apply our knowledge to communities that are traditionally not scientific, we take what I call an arm's length approach. Right? It's a pretty common approach in which we're not interacting much with law enforcement. Right? As scientists, what we do is we develop and test procedures in our labs that we say are going to be useful for you. And then we say, here you go. Use it. Or we might even try to sit there and think about how we can implement it for you, right? But the problem is that those procedures were all developed without the involvement of the end user in the process of developing those and testing those procedures. We say, well, I know how memory works. I can figure out how best to test memory. And we develop something that ultimately won't be effective in practice because it just can't work. The best example that I always come up with here is back in the 90s, there was one person who demonstrated that in theoretical basis, there was theoretical basis to it, that if we construct a 100-person lineup, that will significantly reduce false identifications. Well, yeah, but is that really practical? Is that ever going to actually happen in actual law enforcement investigation? No. So then why are we wasting our time doing that? If we just had a conversation with them to begin with and they say, yeah, there's no chance in hell that we're going to do that, right? Then maybe we wouldn't have wasted our time and wasted the editor's time and all the reviewers' times and wouldn't have taken up space from my article that got rejected, right? 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 It's not, advancing the science doesn't mean that it's advancing the practice, right? Also, another problem is that on the other side of it, law enforcement agents are often acting independently to interpret the science and develop the practices without bringing the scientist into the discussion. And so they're saying, oh, we can interpret the science, right? The democratic experimentalism. Develop your own policy as long as it's based on science. Okay, so they give an assistant chief the responsibility of go look through the science and figure out what the best practices are. And so they read something and say, yep, okay, I think that's how we can implement it. Right? Basically, we're completely separate. We call ourselves applied psychologists, but it's very loose of saying how applied are we. We're trying to apply the psychology. We're not trying to do the psychology in the applied setting. And that's what I want to stress with you today. That's what is the biggest flaw with these approaches. And if you want to fix it, if you want to be more effective in these applied settings, that you have to start integrating everybody together and collaborating from the ground. And that's what we've done here in Washington. So what I want to talk to you a little bit about is kind of like what the early efforts were in Washington and then what our changes are, and then go through and demonstrate some of the work that we've done, how we've done it, and seeing how we're integrating this more collaborative process to result in more endorsement, more buy-in from law enforcement, from the prosecuting attorney community, and ultimately, as we hope, more effective change after we get through the process, because we're not through the process. We're still in the middle of it right now. So in Washington, I have this up here because I just want to demonstrate that it's kind of intuitive that people are insular in how they go through their approaches, especially in the legal system where advocacy is such a central part of our U.S. Legal system, right? We see that everybody's kind of trying to do things independently. From the 90s up to the year 2000, everybody's doing it independently, right? Law enforcement, some are making changes. Some are making some really good changes, right? But they're going through and doing that voluntary compliance. But it's just independent agencies or organizations that are doing it, right? Prosecutors in Washington, one of the members of that original NIJ working group is a prosecutor in Washington. And so he's really kind of taken the lead in the state of trying to promote best practices consistent with that. So there's like the prosecutors are working independently to do this, separate from law enforcement though. Defense attorneys have been attempting to amend and adopt new court rules of how things are going to be evaluated. But again, everything's being done independently, right? And the Innocence Project Northwest also, they're based out of the UW School of Law. They were doing a lot of work, trying to look at, can we get behind court rules? Can we engage in education? A lot of what Richard has looked at here. Can we better educate the judges, the attorneys, the law enforcement on how to do these things? They were considering doing a legislative mandate. and endorsing that and trying to push that through the state legislature to try to get something done. But everybody's doing it in piecemeal. Nobody's working together collaboratively. And so 2010, things changed a little bit, okay? So in 2010, a cop, a psychologist, and a policy attorney walk into a bar. And not really a bar because it's Seattle. You can imagine it was actually a coffee shop, okay? Right? But what happened there is in 2010, I left my position at FIU and I moved up to Seattle. And I started contacting people in various agencies throughout King County, specifically the Seattle area, and trying to talk to them about what's going on here in Washington, what's the landscape look like, and finding out all these independent efforts. And it just so happened that there was a detective from the Seattle Police Department that was really interested in reforming practices internal to the Seattle Police Department. There was a policy attorney from the Innocence Project Northwest that he had reached out to her because he heard her give a talk at some symposium. And so he reached out to her. And then I had reached out to her. And so we kind of just started meeting at coffee and talking about what can be done inside Seattle to engage in better evidence-based practices. Then we started to realize, well, Seattle's in King County. We should really have the prosecutors involved in this. We reached out to Mark Larson, who was the prosecutor that was part of the NIJ working group, and said, can you join us for these discussions? And in the course of focusing on Seattle, we realized we have an opportunity here to do something much larger than Seattle. And so over a couple years of very slow discussion, trying to build trust amongst everybody and all that, in 2013, a working group, an eyewitness committee was formed in Washington that consisted of people representing all interested parties, defense attorneys, prosecutors, law enforcement, and importantly, not just law enforcement administrators, but the investigators and the patrol officers, the people that will do day-to-day be engaging and doing these practices were in the room. Scientists are there, right? And our goal was that we wanted to identify what are the best practices that we can use in Washington State and work together to do it. Not dictate to them and say, now do it, but really work together to identify this. And importantly, take that next step of how can we effectively translate it from policy to practice and focus on there. Now, what we did, we started to review the existing reforms efforts that have been done. And then we looked at the relevant science to try to figure out what practice are well supported with research and theory, right? And then also identify what opportunities there are for us to engage in new research, right? What ideas did law enforcement have that we can then look and say, well, there's not any data on this. Maybe we can go and collect some data, right? And I have stuff here that I'm going to skip through because I know I'm going over time. But one set of studies that we did of where we're sitting there talking about things and saying, they're asking me, okay, can you go find what's the science on this? I don't know of any. Let me go look and see if I can find something obscure. There's nothing there. Okay, you know what? Let's go do a study. Let's go try to do some research that's informed by the practitioner that they say maybe this is a way that we can effectively implement it and go see, does that actually work? Right? And collaborating, building the science together rather than just preaching to them what the science is. All right? And so I'm going to skip over, I guess I'll come back here. So initially we identified 18 different things that we could try to implement and reform. All right? I just want to put up 18 here because ultimately we decided against 18. And I'll explain to you that in a second why we went against that, okay? So that's what we did. And so I'm going to skip over this blinded part because this is the studies that we did, how we used their recommendation to then go do the science to try to answer the questions they had. What we ended up doing, though, after talking about this for a period of time, was we decided on a targeted approach of sitting there and identifying, we're going to go with science-based minimum standards. We moved away from a best practices approach. A best practice approach is saying, this is exactly how you should do it. The resistance of law enforcement, again, of mandating to them what they should do, was palpable. And so we said, you know what? Rather than saying exactly what you should do, we're going to say, at a minimum, these are the things that you should do. Feel free to do anything else you want to do. But these are the things that, at a minimum, are the most critically important things to do. Does that make sense? Right? And so we adopted a minimum standards approach. We wanted those minimum standards were determined by a few things. First, we thought that it was important to give a short list of things because we didn't want to inundate them with too much. 18 things, that's huge. Especially since we know we're going to want to do training on it. Now we have to try to train them on 18 things, right? It's just a lot to enact right now. So we figured we can do the most important things now, and then we can always add to it down the line, right? We also, in this, we wanted to avoid the infrequently used procedures, things that they didn't use a lot, right? Like composite sketches. There's a lot of problems with composite sketches. I will say the biggest problem with a composite sketch is that if you see a composite that looks like the suspect is probably innocent. Because it is nearly impossible to construct a composite that actually looks like the perpetrator of the crime. Right? There's a ton of data on that show that we are not good at constructing composites. All right? And the composites rarely look like the people, even people that you know well. All right? I almost got divorced because I constructed a composite of my wife, and she was very upset that that's what I thought she looked like. Okay, right? Even people you know well, you can't construct composites well of. Imagine somebody that you just saw for 30 seconds, right? We're just not good at it, okay? But they're very infrequently used, and so we weren't going to address that here because we wanted to focus on the things that were going to have the maximum impact, the procedures that were more often used. We also wanted to focus only on those in which there was clear scientific consensus and a theoretical basis for that, for why that's an effective procedure. Right? So anything in which there was ongoing debate in the scientific community, we just didn't address. Okay? And then we wanted to focus on things that have been shown to either increase the accuracy, the probative value of the evidence, or if it doesn't increase accuracy, it at least decreases the likelihood of a false ID. Okay? And then we lastly focused on the cost and benefits, the practical considerations of how expensive is this going to be, what are the manpower needs of agencies, can we recommend things that small agencies can actually do with their limited budgets and their limited manpower. Does that make sense? Okay. And so we went from 18 to 6. We identified 6 minimum standards that met that, and it's not as important as to what these are. I'm happy to share them with you afterwards. I'm going through it just to give you an idea of the process. We could have thrown out 18 different things that would be best practices, but instead we focused on these criteria through this collaborative effort with everybody in the room and agreed upon 6 things. Now importantly, we agreed upon these 6 things as a group part of this committee, right? Just a small group of people that represent these individuals. Well, because everybody was involved in the process to begin with, as soon as we took this stuff to the prosecutors and to the sheriffs and police chiefs in the state, it was almost immediately adopted because they were involved in the process. There was no fighting, there was no bickering, there was questions clearly, right? But because everybody was in the room from the beginning, they adopted it almost immediately. And they adopted it and not just said, hey, this is good, but they said, send it out to their constituents. The prosecuting attorney said, we're going to send this out to every county. And the elected prosecutors were there as part of the agency and saying, okay, I'm going to give this to my prosecutors to say, hey, this is what we want to see in the cases that you're looking at. The sheriffs and police chiefs are giving it to their assistant chiefs, right, that are in charge of investigations and saying, this is what we want to see. Right? Now, ultimately, we could stop there and pat ourselves in the back like what almost every other jurisdiction has done, right? And say, great, they're giving it to them. But saying this is what you want to see is different than giving them the tools for actually how to do it. And so that's the second step that we went to, okay? We wanted to sit there, and now this is what we're doing now. We're in this process. We have this adopted. We're now moving on to the second step now. How can we effectively translate from policy to practice, right? And so there's 3 steps there that we are working on here. First is to identify what are they currently doing, because we don't know how to change until we know what needs to change, right? If they're doing a lot of these minimum standards already, good, we can focus our efforts on others, right? We have to know what we need to train to, right? So that's the first step that we did. Then we wanted to focus on how can we give them better tools that they can use in the field to assist them with doing these practices, right? Investigations, especially immediate investigations of criminal events. You guys familiar with the term show up? Yeah? Anybody familiar with the term show up? I know a couple of you are, right? I know at least 3 of you are familiar with the term show up, okay? All right? You guys have seen show ups before. Have you ever watched Cops? And you sat there, and all of a sudden you see like they detain some guy, and he's standing in front of the convenience store, and then they bring a witness over in the back of the cop car, and they shine a light on the dude, and they say, "Is that the guy that you just saw rob you?" And they invariably say, "Yes." Okay, because show-ups are not good ID procedures, okay, right? But that's a show-up. Show-ups are dynamic situations. It's an active investigation. Law enforcement's coming. They don't know how many suspects there are. They're trying to secure the crime scene. They don't know how many witnesses they are. It's still ongoing, dynamic. One officer might not know what the other officer is doing. It can be really complex, right? And so the idea here is that it's easy in those situations to forget what it is you're supposed to do. So can we develop some tools that they can use, some aids that will help them in that dynamic situation? And also in the less dynamic situation when it's a lineup as well. And so, real quick, what are they doing? So we did a survey here of law enforcement in Washington to try to figure out what are their current practices. Ranged from some small agencies to some large agencies. Ranged across whether they're patrol officers, administrators, or actual investigators. And basically what we found here, the take home from this, is that they did some of our recommended practices already. They naturally did some of them. They provided good instructions. They are also smart to say, or to not say to the witness afterwards, "Good, we thought it was him." Okay? But those are recommended practices, right? Don't say, "Good, you got him," and give them instructions that will not bias them towards picking somebody. They're already report doing that. So, okay, good. They understand that this is a way to do it. But they also engage in a lot of things that aren't good. And so, okay, we do know that we're going to have to train, and these are the things that we're going to have to train on. Okay? Then with that, a lot of these you'll notice here are about conducting show-ups. And so now it's like, okay, well, how can we go about effectively getting them to do better practices in the field? Right? Especially with show-ups that are dynamic situations. And so what we did then is we took the next step of trying to develop some field aids, some things that they could use in the field. And the reason we did this is we thought of, let's use checklists. Let's use forms. Because what we're talking about here is a specific procedure that we want them to engage in. And so maybe we can use a checklist. And we know that checklists are commonly used in other areas of law enforcement. Right? We can see checklists are commonly used with suspect forms. Right? Miranda. Right? They'll have a specific form with the Miranda instructions, and they'll have the suspect sign it indicating that they understand their rights and they're knowingly waiving their rights, right? So let's do the same thing with witnesses, okay? We also know that there's procedural and informational checklists out there in other aspects of law enforcement that they say these are the procedures that we do, especially when it's in a dynamic environment, right? So this is just one that I have of if there's a citywide incident in New York City, this is how they manage it. Right? This is how they go about doing it. Right? They have a checklist for how to go about managing a large citywide situation, which is important because you know how many police officers how many police officers you guys have in Grand Forks? You know that? Commissioned law enforcement, not employees of the police department, but commissioned law enforcement officers in the Grand Forks Police Department? 84. Right? Do you know how many New York City has? Over 36,000. Right? So if we're trying to organize a lot of people and try to figure out what we're doing, we have checklists that we can rely upon. Cool. Okay. So it's used there. Another spot that we look to, though, for this is trying to figure out what we can do is we started to sit there, and I'll be honest, this kind of came from my daughter developed a new friend in kindergarten who was a former naval aviator, fighter pilot. Okay? He now goes around the country teaching people on how to do leadership better and all this stuff and business decision making. But he's sitting there talking about things, and I'm like, holy, we can use this stuff, right? We can look at checklists have been used in other areas where dynamic decision making has to occur. We see it in aviation. Right? You guys know there's pre-flight checklists, thankfully, right? They have pre-flight checklists, right? But there's also, if there's an emergency, there's a specific set of checklists that they go through in an emergency to make sure that they don't mess up on the procedure. Right? Medical fields. We see it in medicine. This Barinholtz study, this was done at Johns Hopkins University. They found that incorporating a checklist went from having 1.4 1.4 infections per 1,000 patient days. I know it doesn't sound like much, but basically what they found is incorporating checklists went from having infections after critical surgery to having 0 infections in their data after critical surgery. They estimated that it saved them in a 2-year period over $2 million in 16 lives. Subsequent studies done in the field actually have continued to show the benefit of checklists in medical settings, such that the World Health Organization now has developed checklists for all types of medical procedures. Right? They're beneficial elsewhere. Why the hell not in law enforcement, in dynamic situations? And so we developed a bunch of checklists for how to conduct show-ups, for how to conduct photo arrays and lineups, and we sat there and said, good, we've conducted these, but now we want to work with them. It's one thing to sit there. We could have done is said, hey, it works elsewhere. Here, use them. But we wanted to work with them. And so what we did then is we did a field study of these. Taking 256 officers from different agencies. I'll be done here in a minute, Andre. Okay? Again, a mix, a variety of the patrol officers, detectives, supervisors, and then some of them didn't identify what their role was. And it represented the same 8 agencies that we had initially. What they did is they used these. They agreed that we're going to use these in all of our identification procedures for an 8-week period. And we got feedback from them. Immediately after they conducted the ID procedure, using the checklist, we would collect a short survey from them, and then we did an exit survey with them afterwards. And then, once we got the data from the exit survey and started to see trends in the data and all that, we then scheduled and conducted private interviews and focus groups with them to really get them to explain to us what were the pros and cons of these. Were they effective? Were they not effective? How should we tweak them? What should we do? And so on and so forth, right? And basically what we found is that the majority of them said, yeah, it's a good idea. Let's do it, right? We can benefit from this. We can effectively implement it. But, as with anything, there were things that we had to tweak, okay? For photo arrays and live lineups, the vast majority of officers agreed that, hey, these are useful. Maybe we need to tweak some wording on them. Maybe we have to, we have to do some modifications to them. But overall, for photo arrays and the physical lineups, they were on board with that. And they had a lot of great perceived benefits. They thought it was really important for the consistency aspect. Make sure we're doing it the same way every time, right? Which is the benefits of aviation checklists, which is the benefit of the medical ones. Do it the right way every single time, and this helps ensure that, right? It helps with full documentation. They also saw some benefits at trial of it improves. If I sit here and just say, boom, how's the defense attorney going to attack me? Right? How are they going to sit there and say, what did you do? And say, this is what I did. Right? And it's approved. Right? It's best practices. Right? It's benefiting them at trial. They did have some concerns because it does require some time to do. Right? Okay? But generally speaking, they liked it. For photo arrays and lineups. They absolutely despised it for show-ups. Absolutely hated it for show-ups. All right? And the main reason for it is because show-ups are this dynamic event, right? Where we have to be fast. We have to go investigate. We have to control the scene, especially if it's a crime in which there's multiple officers responding to at one point in time. Now, I might not know all the information that's necessary to complete the checklist. I might just have my supervising officer sit there and say, hey, you need to drive this witness over there. So I don't know what the description was that the witness provided of the suspect to write on the form. I don't have that information. I'm just doing what I'm supposed to do right now, okay? Right? And then also, and this is a valid one, and this one actually I noticed more. I'm working on a case right now in which we have recordings of the witnesses at the scene of the crime, and it's a gang-involved homicide. And what happens if you live in a community and it's a gang-involved homicide and you talk? Right? What happens to snitches? Right? Okay. So they don't want to talk. They fear the concern. And so now all of a sudden, if I'm having a witness sign a form, right? Maybe now they're going to say, whoa, I'm not going to cooperate. Right? And so we took that feedback from them. And what we're doing is we're transitioning to something completely different. We're saying, all right, rather than you having a form that you have to complete and sign and the witness has to complete and sign, let's just give you a little training guide. Right? Let's give you what instructions you need to read to the witness on one side, reminder of what all the steps are of a good show up on the other side, and you have it as your pocket guide there. Right? And if that doesn't work for you, then we'll just give it to you. You're going to have your notebook on you anyway, so you'll just have it all printed on the inside and outside pages of your notebook. Right? So they have it available to them to use. But they're going to be more likely now to use it. Why?
It's easy.
It's readily available, it's easy,
They've been involved in the process.
and because they're involved in the process. We're not just saying, hey, use these forms. We're saying these are things that you're involved, you're testing with us. You're telling us what will work. We're working with you. We're saying what are the ideal procedures, and you're helping us figure out how to implement them most effectively in your practice. Does that make sense? Right? And so then the other ones, the modifications we're making is really more about the wording on the other forms. Okay, so we've made these modifications. And so what are we doing now? Well, the one thing that we're doing now is the 2.0 field study. So we're getting ready to launch this here. It's going to be another 8-week evaluation. We're going to use some of the new agencies or some of the same agencies that were involved in the initial evaluation so we can get feedback from them on, is this an improvement compared to the old one? But then we're also going to incorporate new agencies that weren't involved so we can get independent evaluations as well. And again, we'll take the feedback and we'll go through. I mean, it's just like rolling out new software, right? Okay, we're beta testing, right? And if we have to tweak it again, we'll tweak it again and we'll go do another study and evaluate this. But the whole point of this is that we're developing approaches that are hopefully going to be able to implement the policy. And we're doing it in a way that the end user is involved in the process so they can help decide what is going to work for them. Because the worst thing to do is to develop something, give it to them, and they say, I can't use this. And then they just throw it out the window. Right? Also, we are working on developing training. This has taken a while. We need training. Our officers in Washington State, 66% said we want more training. But the important thing that we're trying to figure out with this is identifying what training is going to be most effective. There's absolutely no published research that actually shows, does law enforcement training actually result in changes in how law enforcement engages in practice? There's a lot of stuff there that says, think of it like your teacher evaluations, right? At the end of the course, did you like the instructor? Do you feel like you learned something? But there's nothing that actually follows up afterwards to say, officers that took this training, what did they actually do when they were on the job? And so because of that, we're struggling to find what are the most effective means to do the training, to construct the training, to administer it, because we want to make sure that we're doing things that are going to result in actual change. And so that's taken a little bit more time than we expected. But we're developing the SOPs, the procedural guide of saying this is exactly how you're going to go do it, okay? Standards of practice, okay? That explains why they're used and what they are. And then we're also developing both Law Enforcement Academy and in-service for active officers. So I'm a little over time here. I'm just going to finish up on this okay, so what's the novel approach here that we're doing? The first thing we're doing is we're avoiding this arm's length approach of where scientists just dictate to law enforcement and law enforcement just does things without really conferring back with science, okay? We're really actively embracing from the beginning this develop and test model where we're working together to be collaborative in this, all right? We're also employing what's referred to as a new governance model. And basically the idea behind new governance, and this comes from any organization, it's from organizational leadership research, the phrasing, the term new governance. And the idea behind this is that ultimately you're letting the people that are going to be governed by the rules be involved with deciding how it's to be implemented, right? Ultimately, we're involving the end user in the decision process from the beginning, so they have a say in how they're going to be governed. Right? So it's not just mandated to them. All right? We're also focusing on implementation and not just adoption, right? It's not just about getting the policy passed, but actually getting it to lead to practice. And we're also looking to other fields for guidance on how we can maximize this. We're not just focusing internally on psychology or on law enforcement practices, but we're trying to see where have there been problem isomorphs? Anybody that's a cognitive psychologist knows what I mean by this, right? Where are there problems that arise in other areas that might look different, but at their core they're exactly the same? And how have they solved those problems? And can we then take some strategies they've used that's been demonstrated to be effective there and bring them over here? So we're not reinventing the wheel. We're just adapting and transferring knowledge into a new policy and practice. All right? And time-wise, I'm over, so I apologize for that. But that's all I had to talk with you about today. So I thank you for Well, thank you. Okay. Let's stop talking. Any questions or anything, you guys? Yeah.
Did you get any, like, different responses or sets of feedback based on, like, the county that you were getting the information from?
We did not. We expected that we would. So Washington is, I don't know if you guys know the geography of Washington, but in Washington there is a set of mountains that go, the Cascade Mountains go pretty much almost exactly down the center of Washington, right? And if you just look at any political map, the west side of Washington is blue and the right, or the east side of Washington is red. Right? And so we were actually cognizant of when we were selecting agencies to make sure we were sampling agencies of different sizes from both sides of the mountain, right? Because